Hey, good evening, everybody. John Skiba here from the Consumer Warrior YouTube channel. It's Thursday night. We're here like we are each and every Thursday night answering questions, talking about all things debt related. Again, my name is John Skiba, and I am a consumer protection attorney and a bankruptcy attorney in the state of Arizona. And what we do here on the channel, and the whole idea behind the channel, was to provide information, tips, strategies, resources for people who are dealing with really serious debt problems. I often joke that we don't just dabble in debt. We deal with the serious stuff. We deal with debt collection lawsuits, wage garnishments, bank levies, all that kind of stuff. So what I like to do on Thursday night is really have this be a conversation. If you have questions, go ahead and put them in the chat section on YouTube or on Facebook. I'll put it up on the screen. We can talk about it. As I say each week, I can't give legal advice. I am a licensed attorney in the state of Arizona, but I'm not licensed anywhere else. And this is just some guy on YouTube. You should not take this as legal advice. I will try to point you in the direction of places you can get some resources to maybe help you in defending yourself. If you're in the state of Arizona, my number is scrolling across the screen. My website's there. You can check that out. I do free consultations for residents of Arizona and people who have Arizona cases. Otherwise, if you look in the chat section, I do have a link to my Consumer Warrior University. I have over 16 templates, instructional videos on how to deal with debt collection lawsuits, drafting answers to complaints, motions to vacate default judgments. And as always, we're sponsored by Solo Suit. Their information is below this video, and the information there. Solo Suit can help you using technology and really harnessing that to do things like drafting answers to complaints, debt validation letters, and even debt settlement. So go ahead and check them out. They are a great company, great program, things that can help consumers who are dealing with some pretty serious things. So, each week I usually go on there and grab some comments off the YouTube channel that I haven't been able to, respond to. Something I wanted to talk about today is being a little bit more proactive with things and to discuss bank accounts. I can tell you something that's kind of interesting. So doing bankruptcy law, here in Arizona, I'm able to see, I always say I'm the financial version of, proctologist or whatever. We see everything. I see your bank statements. I'm seeing what people are spending, kind of the good, the bad, the ugly as it relates to your financial situation. And I've seen that for almost 20 years. October 24th will be 20 years that I've been doing this. And because of that, I see a lot of trends, and maybe can give you some tips on things that'll help you to avoid some problems. Now, bank accounts. First of all, we all have way too many bank accounts. It used to be early on in my career, you'd see you'd have a checking and a savings. Now people have 5, 10, 15 bank accounts for unknown reasons. Even a business owner, you don't need that many bank accounts, but people have a lot of bank accounts. And the reason why this can become an issue, particularly, because it's so easy to transfer money back and forth, it brings up a lot of questions in like a bankruptcy setting. Trustees try to track all those funds, and it creates a lot of extra work for the trustee, for your attorney, and for you, because they're going to require you to explain all of that. But the bigger thing as it relates to bank accounts that I see where the biggest issue that people run into is, people get into trouble financially. And if they have children, they do something that I think it is good. They open up an account for their minor children. So the bank account, it's a minor's account, M-I-N-O-R, a minor account, not M-I-N-E-R, M-I-N-O-R, a minor account. And the minor account, the parent's on it because the child's not old enough to have the account on their own. Well, kid grows up, turns 18, leaves the house. Mom and dad stay on the account just indefinitely. And mom and dad get themselves into some financial trouble. They get a judgment against them. They get hit with a bank levy, and they seize the kid's funds. I see this multiple times during the week. And so I thought it'd be good to bring it up and say, here's kind of a pro tip. Particularly if you're finding yourself in a situation where you're uncertain about your finances, your accounts are going into default, you're not able to pay credit cards, you're at risk of having a lawsuit, my recommendation is either take your name off your kid's account or have your kid get their own account. This can apply for adults as well, maybe that have elderly parents. Sometimes they'll put their name on the account just in case they need to assist them. I get that, but if you find yourself in financial difficulties, having your name on somebody else's account opens them up to having their money seized. Sometimes we can unwind that, or we can segregate, whose money is whose, but it makes it much more difficult. So that's just a tip there, that if you are dealing with these kind of things, is to be careful about which accounts your name is on. And if you're not using the account, close it. There's just way too many bank accounts. You're making my life more difficult. I'm just thinking about me. All right. So if you have any questions, let's go ahead and throw them in the chat section. A couple questions here. Christine was here bright and early, said, if I can get up over it. Hi, what field of law deals with unfair practices of retailers and how they treat customers? Me, my household are banned from a department store. That is unfair. We didn't violate any policy. I saw your question, Christine, early on before we got started today. And you right out of the gate here, you're kind of stumping me, because I don't know if there's a particular law that would be involved. I mean, unless it's something where they're discriminating, based upon protected classes out there, like race. If they're discriminating based upon that, then obviously there's some civil rights issues. You could talk to the Attorney General's office here in the state of Arizona or wherever you are. That being said, you would probably want to talk to maybe like a personal injury attorney. They would be the ones to be able to help you with something like that. Or if it, like I said, depending on why they're doing it, it may be something where you'd want to bring it up to like an attorney general's type office to have them deal with it. All right, let's see here. Me, MG Glenn, says, I've moved out of Arizona. Do debt collectors need to reserve me? I informed the court I was moving, but I didn't have an address at the time. So I guess if they've already served you once and your case is moving on, do they need to reserve you? No. But it is important that you change your address with the court. The court system, particularly here in Arizona, the state court system, they often deal in the mail, is how they send things after the initial service takes place. So, and like the attorneys, that we send things back and forth. You can probably see behind me the giant stacks of paper. I get tons of mail every single day. And so the mail is how they deal with it. So you need to make sure you update that, but they don't need to reserve you. Now, if they never served you in the first place, if they filed the lawsuit and they never served you, then yes, they would have to serve you. And then there would be a question of whether they had jurisdiction in the new state, or whether that's, that venue is something you could object to. Mike and Jen said, how do judges feel towards collection attorneys? Will the judge even consider the arguments? I'm losing my voice already. Will the judge even consider the arguments of someone who is pro se? Yes, they will. I genuinely think judges try to be fair. I think they try to, be the umpire. They call it as they see it. That being said, the one thing I can tell you, pro se's, people who represent themselves, pro se litigants, what feels super unfair when they get into the court process. One is Arizona law says that the judges have to hold you to the same standard as the attorneys. First of all, that doesn't seem fair, because the attorneys do this all day. This is their day job. They went to law school, passed the bar, all that kind of stuff. And so it's going to be difficult for you to perform on the same level. However, I can tell you that most judges do give pro se litigants somewhat of a break, on deadlines and filings and all that kind of stuff. But the thing that feels unfair to most people when they come into the court process is that, deep inside us as Americans, we're all about, truth, justice, and the American way, that kind of thing. And we feel like that we should be able to go in there and say, look, this isn't fair what they're doing. Let's say portfolio recovery, they paid 3 cents on the dollar for this, and now they're wanting to sue me for 30 grand, and they spent $3 or $30 on it, that kind of thing. In the litigation process, there's a very set way that things are done. It's very rules-based, it's law-based, obviously, and there are certain procedures and things that are in place that are designed to make sure that the best evidence, the best information, and the right result is reached. However, it can feel incredibly unfair, because you're just sitting there saying, you know what, I need to tell my side of the story. I need to say why this is unfair. And a lot of times the rules make that very difficult. I know I've seen it happen before. I've done it going against a pro se litigant in a trial type setting. You can object almost to everything they ask because it's usually hearsay, there's lack of foundation, things like that that are designed to protect the integrity of the system, but at the same point make it very difficult if you're not familiar with the rules to get the information out and be able to deal with it effectively in a courtroom setting. So long-winded answer that I do think try to be fair, but often the way that people present the information, it's done either in an incorrect form or it's done in violation of the procedures or the rules. And so it feels like the judge doesn't want to even listen to you, but in reality, they're just following the rules as far as what can come in. And that's why I say that the judge should hold, particularly like debt buyers, to such a high standard. It's one thing for junk debt buyer company to come in and say, hey, John Doe, Jane Doe, you owe this money to us. It's a whole nother thing for the court to sanction that with the judgment. Because once they sanction it with the judgment, that stands for the proposition that, hey, it's gone through this filtering process to make sure that the information is accurate and correct and right. And then they're going to sign off on that, certify it as a judgment that allows them to take money out of your paycheck and your bank account and lien your home, cause all kinds of chaos. And so if they're coming in with just this shoddy evidence and documents that don't line up like they should, then no, I don't think the court should grant judgment. So I think it kind of works both ways there as far as how they deal with it. So, all right, let's go on to my main man, Alex, down in Yuma. Can you be sued for a foreclosure if the lender takes a loss on your house? This is a good question. It's a good Arizona question. And, we saw that the big peak of foreclosure in Arizona was 2008, the Great Recession, when it was just nuts. Yeah. Tons and tons of foreclosures. Now we're starting to see it a little bit more. Forever I didn't, the property values were just spiking like crazy, and we didn't see a whole lot of foreclosures going on in the state of Arizona. We're starting to see more. We're starting to see more people fall behind on their house payments, and kind of looking to different options of what they can do. In Arizona, if your house goes through foreclosure, and through that process is called the notice of trustee sale. And I tell everybody up front, it's not a quick process. The time from when you stop making payments on your house until they provide you notice that they're going to try to sell it, usually you're going to have to miss 3 to 4 payments, often many more. And then they have to provide you a notice of the trustee sale, and they have to come and tape it to your door. And from the day that they leave it on your door, they have to wait an additional 90 days before they can actually sell your house. So nothing happens quickly. And if you're able to get caught up on the payments during that time, or if you're able to get like a loan modification or something like that, you can save the house. Or if you file a Chapter 13 bankruptcy during that time, it'll stop the foreclosure. But to get to Alex's question, what if they do it? What if they go through and they foreclose on your home? And then let's say there's a balance that's left over. We call this the deficiency balance. So let's say that you owe $500,000 on your house, on your mortgage. They sell the house at a trustee sale, they foreclose on it, and they only get $300,000. So you owed $500,000, they only got $300,000, so there's $200,000 that's left, that deficiency balance. In Arizona, they typically cannot sue you for it. Arizona is what's known as an anti-deficiency state. And so there's a statute on the books that says if it's your personal residence, you actually live there, they foreclose on it, and it's a single family home or duplex or whatever, and it is on less than 2.5 acres, that they cannot come after you for that balance. The anti-deficiency, it does not allow them to pursue a deficiency balance. So that does not apply, though, to things like if you have a rental home, second home, vacation home, something like that, then they can come after you for the deficiency. So good question, Alex. All right. Derek says, hearing on a motion to compel discovery next week. Court cases cited, identity fraud papers submitted, proof that I have asked for a contract between Midland and original creditors. Thoughts on these hearings? So the hearing, it sounds like if the hearing is on, you bring up a good point, because it kind of goes back to what I was saying about procedure. If the court has set a hearing on your motion to compel discovery, that will be the only issue that they hear information. So it's usually very narrow. It's not like they set a motion to compel discovery and then they also want to talk about motions for summary judgment or any other things. So it's very, very narrow questions will be dealt with at that hearing. The motion to compel discovery, my guess is that you requested information through the written discovery process. They have not provided it. So you filed a motion to compel to have them turn it over. So the court is really going to say, I mean, I know in Arizona, it's actually kind of informal. The courts are going to go, what's going on? Why aren't you turning it over? And, you may be asking for something that they're claiming is privileged, or something that they feel like they don't need to turn over. If you're asking for like the forward flow agreement or the purchase contract, most courts, at least in Arizona, will require that they turn it over. They might allow them to do things like redact everybody else's name, like if there's a bunch of accounts. Sometimes they'll allow them to redact the amounts owed. I fight against that. But they can't just redact the whole thing. And they've got to provide the document, because that's the document that gives them the right to even be there in the first place. But for like a purchase agreement or a forward flow agreement, they don't even have standing to be there. That's the document that says that, hey, they can step into the shoes of the original creditor and file the suit. So I would just go prepared to tell the judge why you need it, when you requested it, and if they've made any effort at all to respond to it. All right, this question says, can you lose your primary residence in a Chapter 7? This is also a good question, pretty timely, particularly here in Arizona. So Chapter 7, the idea behind Chapter 7 of bankruptcy is we're going to get rid of all your unsecured debts like credit cards, medical bills, personal loans. And the court's going to look to see, do you have any assets that can be sold for the benefit of your creditors? Now, if they sell it, so most assets are protected though. So like your primary residence in the state of Arizona, you have a homestead exemption. And that homestead exemption protects up to $400,000 of equity. So not just $400,000 of value, but of equity. So if you owe $200,000 on your house, the value of your house can be up to $600,000 because you can have there's equity that's built in there, and that'll be protected in a bankruptcy, and they're not going to touch it. However, there is a rule, and we're starting to see this come into play in Arizona now because of some recent changes in, I guess it's been a year ago almost, in November, the Prop 209, where they bumped that up to $400,000. There is a provision in the bankruptcy code that says if you purchased your house 1,215 days ago or less, which roughly equals about 3 years and 3 months. If you bought your house within the last 3 years and 3 months prior to filing Chapter 7 bankruptcy, that's a federal law, but how it applies in Arizona, it states that if you bought it in that last 3 years and 3 months, then you're only entitled to the federal exemption, which right now protects up to $189,050 of equity in your home. So it's less than half the amount is protected. However, with the federal exemption, you can double it. So if you're married, you can stack it, and then that brings you closer back up to that $400,000. Some of the trustees I know in Arizona, they're pushing back on the doubling a bit. I've seen a lot of the case law and some people who've done a lot of research on this, and I think you can double it. But for sure, you get the $189,000 exemption. So again, long-winded answer to your question, can you lose it? Yes. If you have more equity than the homestead exemption allows, whether it's the $400,000 Arizona exemption or if you're stuck with the $189,000 federal exemption, if you have more equity than that, you can lose your house. They could sell it. So let's say that that your house was paid for and it was worth $600,000. They could sell it, write you a check for your homestead exemption, which is the $400,000, and then take the other $200,000 and distribute it to your creditors. So that's how that works. I can tell you in most cases, super rare. If there's the excess, if there's too much equity, either you look at a Chapter 13 bankruptcy where you're not going to lose anything, or you could look at a chapter or not file bankruptcy altogether. So that would be something you could look at. So that's a good question for right now, just because we're starting to see that issue come up more, just whether it was purchased in the last 3 years and a bit, because that changes the types of exemptions. Also, if you haven't lived in the state of Arizona for at least 2 years and you file Chapter 7, we have to use the exemptions of the state where you came from. And some states, particularly some eastern states, are insane. I think it's Kentucky has like a $20,000 exemption. I don't know how anybody files bankruptcy and keeps their home if you're there. So that's how that goes. Hey, Derek, thank you for supporting the channel. Sincerely appreciate that. All right. Stephanie says, what alternatives to bankruptcy? My husband is considering single bankruptcy for credit card debt. However, he's now just starting to make some income again. The debt is only in his name. So when it comes to debt, I mean, really, your options are to just pay it, settle it, file bankruptcy on it. The pay it approach, I mean, that's where people incorporate things kind of like the Dave Ramsey approach, the snowball approach, which I think is a good one. A lot of you know that follow the channel. I'm a certified, I guess I was certified as a master financial coach through Dave Ramsey's organization. I've had dinner at Dave Ramsey's house. That's always my claim to fame. I've had dinner there with him. So I am all about that approach. I think it's a good one. I know in certain situations it doesn't work. Mostly situations where you're dealing with really excessive debt and maybe the income just isn't there to be able to make that work. That's my opinion. But I think the debt snowball type things will work. The Financial Peace University, I think it's excellent. It's one of these things I want my kids to watch. And I used to teach Financial Peace University. I haven't done any really since COVID, but I know they do it online now, and they've kind of revamped that program. There is, the settlement, a lot of these debt settlement companies out there. I always hesitate a bit with the debt settlement companies because I can tell you what I see on my side and I'm probably biased somewhat because I see it from the bankruptcy side, where what I see is if you hire some of these companies where they're saying, oh, look, just, pay us some money each month. We'll reach out to your creditors and then I'll negotiate some kind of settlement and then we'll pay them off and it'll be great. What they do is you stop paying your credit cards, you start giving, $600 a month to whoever, and then they put it in an escrow account, they build up a balance, and then they reach out and they try to negotiate a settlement. The problem with this approach is your creditors are not on board until they actually get money. And so what I see is, particularly if you have a lot of different creditors, is people will go through this process and then they're paying whoever the company they hired $600 or $700 or $1,000 a month or whatever it is. And all of a sudden they start getting sued by all their creditors and they're not understanding why. And the reason is because until they come to a deal, there's, all bets are off. They're still going to try to do it. Not only that, you're going to be paying quite a bit of money for these companies really just to be your savings account, which sometimes if you struggle with the kind of the self-discipline to do that, it is helpful. If you're struggling paycheck to paycheck, having a big savings account, it's going to be too tempting to say, you know what, screw it. I'm just going to go buy groceries or whatever with this. So those are kind of some of the challenges to that. If your creditors are relatively few or if the debt's fairly minimal, that's kind of the alternatives I look at. Sometimes people, if they haven't paid their creditors in a while, they'll just wait and see which ones get most aggressive and then kind of deal with them as they come. And sometimes, when they're sold to junk debt buyers, you can get a lot better settlements than if it's like the original creditor who's filing the suit. So those are some of the alternatives. The bankruptcy, you can file separately. You don't have to file as a married couple. We do that routinely. In states like Arizona that are community property states, there is some risk there that it's good for you to talk to an attorney about with. Generally, I say that risk is fairly minimal, particularly if your spouse is not even on the account, as far as them having any liability down the road. So hopefully that all helps. I think that's it for our questions tonight. So, hey, everybody, I appreciate you checking in. Again, check out the Consumer Warrior University, my templates, tutorials, kind of for a deeper dive of what we're doing here. Also, down at the bottom there, you'll see the link to Solo Suit. They have a lot of information there and a lot of cool resources. Those are some of the non-bankruptcy alternatives. You can go to Solo Suit. They have some debt settlement tools that are really slick as far as the technology that it uses to help you to get a deal done. So with that being said, I think we'll close it out for tonight. Thank you, everybody, for tuning in. If you do need help in the state of Arizona, don't hesitate to reach out to me, the number below. With that